Last but not least, our third speaker. I'm proud to have here Professor Tal ZARSKY. Tal is a teacher at the Haifa University Faculty of Law and is an extensive writer on privacy issues and data protection. The topic today is about transparency and how we can help better curb these surveillance issues. Tal?
Thank you very much. I want to start out by thanking the organizers of ZARSKY and especially Pascal for putting together a very interesting conference and a panel in particular. And as noted, so within the broader notion of surveillance discussed in this panel, I'm going to focus within that on two factors. So one factor would be the factor of transparency as a possible solution to resolve the problems of surveillance and the shortcomings of such a solution. And within this discussion, I was also asked to bring in some discussions and insights from my work and others on surveillance matters pertaining to commercial activities, right? So we're seeing two sets of discussions. One is discussions carried out regarding surveillance by the state. And another discussion is, so that's Big Brother, and at the same time, discussions regarding surveillance by commercial entities. Some refer to them as Little Brother, but they're not very little. And of course, the interaction among them is also a point of contention. But even if we only focus on instances where commercial entities gather information for their own uses, we have discussions there, and we have discussions as to the role of transparency in that context. So this brings us to what I'll try to achieve in this talk. So what I'm going to try and do now is provide you with some basic tools to discuss various calls we hear for greater transparency in the various contexts that I mentioned. And thereon, when you have such issues come about, you have additional tools, analytical tools, or knowledge to engage in the balancing which calls for transparencies require. So what we'll talk about will be introduce some basic concepts. We'll talk about the justifications for transparency and the shortcomings. And then we'll talk about as much time as we have, three specific contexts where we could talk about transparency, tracking the trackers, and then two additional analytical case studies. Okay, so, but before we move forward, I think we need to set some context. So one is very simple with regard to surveillance. We talked a lot about it. So here I have the slide of what I mentioned in my overview. But even within government, we have very different discussions and balances regarding law enforcement, and on the other hand, national security. And even within the commercial context, we have use in commerce, for instance, providing credit, generating advertisements, making decisions about employment. Okay, now also, we talked generally about this term surveillance, and I want to provide maybe a more robust discussion here. So mostly we focus about the act of data collection. Okay? But when we talk about surveillance, we need to have a broader picture. We need to consider actions of retaining the information, aggregating the information, analyzing the information, and thereafter using the information. And every one of these specific elements could bring about a different form of transparency. Transparency means something very different when you want to figure out how information is being collected or retained or analyzed. And let me say something else. At times, if you want to assure transparency or disclosure regarding these various elements, you as a regulator must be proactive and require the generation of information by specific entities carrying out these schemes. For example, If you're engaging in surveillance and using information thereafter, and I want some insights as to what you're doing so I could learn about what you're watching, how you're retaining, for how long, how you're collating the data and analyzing. But at the end of the day, I might also want information about the false positives and negatives of the overall operation. And from there, I will be able to derive to what extent these forms of surveillance are justified. Okay, so when we think of transparency regarding surveillance, it's not only give me the information you have, or give me the information you have about me. It might also mean generate information about what you are doing and thereafter show it to me. Okay, and I stalled on the last word because the word transparency also means a lot in different contexts. So there's a related concept, which is that of accountability. Now, accountability is somewhat different from transparency, although transparency at times is understood as a measure to achieve accountability. Okay? But accountability could also be the sharing and review of information internally. For instance, by different branches of the entity or different branches of government. What do we mean by transparency, or transparency to whom? So this could be different entities to whom we deliver information. It could be to the entire public, to specific auditors, and these could be internal auditors within an organization or government. It could be a fellow nation. It could be an external entity reviewing independently the information, however, not sharing it with the broader government. Now, there are two other instances here, because if you talk about transparency, it could be transparency to someone that information about him or her is collected, and he or him should know that such information is being collected. Or it could be something very different. It could be someone that is affected by a surveillance mechanism and wants to understand how such information is affecting him. And this is not the same thing. These two elements seem similar, but they are not. In the age of big data, you collect a great vast set of information and analyze it and set up various profiles, various mechanisms, and apply them elsewhere. Okay? So you have two entities, to speak. You have the entities of those whose information was collected, and thereafter entities whose information about them, information is being used and affecting them. Okay, and as I concluded here, at times, to set up transparency, you might have to be aggressive in your requirements of various entities. What do I mean? I mean that at times, and I'll just touch upon this quickly, many of these steps here are automated, okay? So, a very simple example, at times in airports, you have cameras watching people, that's fine, and you want to know when you are not being watched. But at times you cannot know that in advance because many of the cameras are automated. They set up algorithms and look at specific individuals based at various events, the way they're walking, other intel that's coming in. So the government could say, or the various entities, we don't really know how surveillance is being carried out because of the automated elements being set in place. And we previously had a panel here on automation. And the fact that a process is being automated should not allow an entity to excuse itself from transparency. So we need to perhaps think deeper of how we set up tools to articulate disclosure if a process is being automated. Okay, now, as a lawyer, and some of you are also lawyers, let's say a word about transparency in the law. Now, certainly, transparency is not a concept alien to law. It's not an issue where you have paucity of laws. It's maybe perhaps quite the other way around. You have many laws, generating transparency and disclosure in commercial context, in governmental context. So this is just a brief list of laws you have in the United States, laws regarding government regulating freedom of information, privacy laws to some extent. In the EU, the Data Protection Directive requires notice prior to collection of information, and also requires providing information about profiling practices and automated practices. You have more and more laws requiring PIAs, which is privacy impact assessments, and when doing so, the government provides us information as to how the information, the data, will be collected and later analyzed. So we have many laws on this issue. The challenge here is identifying how the balance should be carried out, because in every transparency and disclosure law, there is an exception for trade secrets, national security, law enforcement. So there's many devils here in the details, and carrying out these balances is crucial. And how will we do so? To do that, we need to delve a bit more into the justifications for transparency. Now, many of them are intuitive, right? In a democratic state, we should know of governmental actions, and that notion is well-rooted in many of the basic philosophers articulating the role of a state. But let's come up with some instrumental arguments very quickly, and we need the instrumental arguments so that we are able to calibrate the justifications for transparency with the various detriments and shortcomings we will soon see. So one point to promote transparency is that transparency promotes fair and efficient policy. Now, why does that happen? Two intuitive responses. One is that when we know what actions are being carried out and these actions are problematic, we shame the policymaker. And when a policymaker is shamed, in advance, that would lead him not to make specific decisions. And on the other end, he will be punished by his voters. If he's a bureaucrat, he will be punished by the political arena. And if he is a commercial firm, and this was just recently mentioned, it will be punished by market forces that are adverse to the various actions that transparency is bringing to light, right? And Justice Brandeis famously noted the power of transparency as a disinfectant. Okay, so that's one notion of transparency. Another notion on transparency, which is very interesting in the specific technical fields we're talking about, is that if we know how things are being carried out and that they have a price, so we could crowdsource, work together to figure out if what is happening, if the way information is being collected and collated and retained and used and analyzed is the most effective way. So going back to the very simple example in the airport I talked about, that we're telling the public how we are being filmed, watched, viewed at the airport at all times. And then people come forth, academics, scholars, even hobbyists, and say, this isn't the proper way. This should be done in a different way. So we're letting out all this expertise that is out there, okay? And we're not allowing it to come and impact many interesting and important aspects of our lives. So transparency allows to bring in many additional sets of knowledge and knowledgeable individuals into a decision-making process. Okay, two additional justifications from very different aspects. One goes to a basic argument of autonomy, right? So if information is collected about me, and this especially goes hand in hand with the EU Data Protection Directive and the philosophy behind it, I have a right to know how information about me is being collected, okay? And if there is no transparency, I don't know about this right. Now, again, there's a problem putting this right in the governmental context, because in the governmental context, we know there's a lot of personal information being collected about us, and we can't really object to it. I mean, we're born and our name goes into the registry, and we can't object to that. And from that until the day we unfortunately end our life, and that goes into a registry as well, the government is constantly collecting information about us, and we can't opt out of that. So this autonomy-based argument has difficulties being implemented in the governmental context, but still has force. And on the other end, transparency is a measure of due process. I am being affected by information being collected, and I want to know why I'm being affected in the same way. And again, in the EU, the Kafkaesque metaphor of having a process being carried out in the back office, in the tower, in the castle, in the courtroom, and not knowing what's happening, that is a very powerful metaphor that builds into the requirement of having transparency. Okay, now quickly on shortcomings. The most basic intuitive shortcoming of transparency, and many people here involved in national security and law enforcement will say it quickly, is that when you know how information is being collected, the subject can game the system, okay? It knows to do various ways, various things, and at the same time could still carry out the negative actions it wants to do. Okay, now, instead of going into the theory here, I'll give a few examples when this does and does not work. So, for instance, there's a camera at the bank, and I want to rob a bank. Now, will it matter or not if the bank tells me if there's a camera there or not? Will it change my activity if I want to rob the bank or not? Now, on a basic level, one might argue that it doesn't really matter because everyone assumes there's a camera in the bank, right? And if I'm going to rob the bank or not, it's not really going to matter. So might as well tell people there's a camera in the bank. It's not really going to change any forms of actions or lead to gaming the system. Okay, but where it might change, right? It might change if people are told what sets of information are collected about them, and they're planning, let's say, terrorist activities or planning to break the law, and they're not really understanding what forms of commercial transactions are being recorded, okay? And therefore, because they take specific actions planning their very negative activities, this information later comes to the hands of government. So if we tell them, we're collecting information from your credit card entities and PayPal and from the internet, so actually they will not use these systems and we will not catch them. Okay, now some of you are feeling uncomfortable because in some contexts this is a bit silly, in some contexts it is not, because the evildoers understand they cannot escape any form of surveillance, and therefore this form of justification is losing its force. Okay, just maybe to quickly point out another distinction here. In some surveillance systems, we use proxies. What do I mean by a proxy? We don't know if an individual is going to hijack the plane, right? So what we do know is that if he has a certain kind of a knife, so he might hijack the plane. So we engage in surveillance looking for specific things such as knives. Now, do we want to tell people that we're looking for the knife? Now, if we tell them, they'll not come on the planes with the knives, but they might still kidnap or hijack the plane. So again, some forms of surveillance inform people, and then they will stop engaging in negative behavior, but that's merely a proxy. We're trying to find out the much more serious actions. Now, if telling the public about how we engage in surveillance will merely help people sidestep a proxy, but still engage in the negative action, okay? So at that point, telling them how we're engaging in surveillance is a problem. Okay, so in the interest of time, I'll just point out two additional shortcomings and then maybe discuss them in the Q&A. At one point, when you have transparency. So that might lead individuals to limit positive behaviors, right? They know they are being tracked, okay, but they have no interest in engaging in anything negative. So that will actually chill various positive aspects. So that goes into the basic form of analysis of balancing. But a point that might not be as intuitive is, once you know, this might be very intuitive for people engaging in law enforcement, once you know what form of surveillance is being carried out and looking at what form of individuals, other people outside that scope might be motivated to engage in criminal activities. This is a problematic theory. It pertains more to instances where there's greater elasticity to engage in criminal behavior, for instance, regarding tax avoidance. Okay? So if you're contemplating to engage in tax avoidance and you understand how you're being surveyed, so in a regular instance, you might say, because no one's looking at me, I will engage in tax avoidance, and therefore this is a justification perhaps for greater opacity. So there's much more to discuss, but I'll bring it up in the Q&A. Thank you very much.
Thank you, Tal. So we still have 30 minutes for questions. As the moderator, I will ask the first one, and then we will open the questions to the floor, and I'm sure you have many questions as we have covered so many topics. My question goes to Ashley. You talked about international human rights law as a way to curb international surveillance. In your opinion, do you think that the ICCPR established an extraterritorial right to privacy?
So it's a good question that people have significant disagreements on right now. I have my doubts that the drafters of the ICCPR envisioned any kind of scenario like the one we're currently talking about. But of course we know that if you craft a law, you do it in the knowledge that situations may change and so on. So I don't mean to suggest that only what the drafters had in mind is where you can apply the law. But there are two real complications as I see it. The first goes to this notorious question regarding the extraterritorial application of this treaty. And the United States has, for some amount of time, and that itself is disputed, argued that the jurisdictional provision in the treaty, which talks about within a state's territory and subject to its jurisdiction, means that the ICCPR was really intended to regulate activities by the US government on people inside its territory. The human rights body that oversees the ICCPR's implementation has taken a different approach and believes that the treaty applies extraterritorially in some circumstances. So this is the second question. Okay, well, so when it thinks it applies extraterritorially, how do you know when? Surely it doesn't apply everywhere, at all times to all people from the perspective of a given state. There's this idea that's come up of effective control. So, and the European Court on Human Rights has grappled with a sort of similar concept. Okay, so where somebody abroad is, for example, in your detention facility, we might say, okay, that sounds like that's a situation in which a state could decide that it had to apply the ICCPR provisions to that person, right, squarely within the state's control. So surveillance raises this complicated question. When you are obtaining either the content or metadata of somebody's communication, are they somehow in your effective control? Is that the right test? And if that is sort of the going test, how do you think about that in the surveillance context? So my bet would be that if you talk to many NATO member states, they would say, it's not clear, this is hard. Maybe the ICCPR privacy provision applies and maybe it doesn't. There's going to be a way that we figure this out, and that is that there are court cases bubbling up, including within the UK and in the European Court of Human Rights. I think we'll consider in the near future how to think about application of the human right to privacy in the surveillance context. But it is a difficult and really important question for this conversation.
It depends. I guess.
It depends. It's a hard analytical question, and I don't envy the courts that are going to have to resolve this question.
Thank you. Do you have any thoughts on that, Lee? Or?
Well, I think what Ashley is pointing to is also just a lack of detailed authoritative commentary on Article 17 of the Covenant. Okay, we have this general comment number 16 from the late 1980s by the Human Rights Committee, but that's a non-judicial body. While its opinions are highly respected, nonetheless, it's a very brief and broad brush treatment of Article 17, and it does not mention the sort of spying activity that you dealt with in your talk, Ashley. So it's very much an open question. And I guess with the cases coming up in Europe, they may well end up being delimited so that they're concerned only with, let's say, the European Convention on Human Rights or EU instruments, and thus there'll be then questions. Okay, does that reasoning then apply to a covenant with a much more global scope?
This came up in the United Nations after Germany and Brazil, their leadership had been revealed as being the subject of NSA surveillance. And news reports suggest that Germany actually contemplated drafting a protocol to the ICCPR that would have clarified that the right to privacy in the main treaty applied online as well. And so you can draw different conclusions from that. You could say, well, okay, there was a lot of support for the general idea of the ICCPR right to privacy applying in the electronic context as well, as evidenced by a GA adopting a resolution in support of that. But you might also think that the fact that Germany thought it was necessary to clarify that by virtue of a potential new treaty or a supplement to the treaty suggested maybe it's not so clear. So I've had debates with people about what exactly to draw from the fact that Germany reportedly was contemplating offering an amendment to or an update to the ICCPR.
Just one other small comment on the scope of Article 17. It's formulated as a right, enunciating a right or a set of rights. There are no, if I remember rightly, no exceptions baked into the provision in the way that you have, for example, with Article 8 of the European Convention on Human Rights. Article 8 is in 2 paragraphs. The first establishes a right to respect for private life, family, home, and correspondence, and then paragraph 2 establishes the criteria that need to be met to justify an interference with that right in paragraph 1. We don't have a similar structure in Article 17 of the Covenant. So even if there is some clarification from a court or another authoritative body on Article 17 and its scope in relation to the extraterritorial dimension, there will nonetheless be questions then, okay, what's the scope of the right to privacy in the extraterritorial dimension? When can that be breached? Under what circumstances?
Thank you. We might take some questions from the floor. Well, yeah, Bill.
Illuminating and an incredibly well-informed discussion, and I'm about to lower the tone, I fear. My question is this: whether you think essentially it's going to be the notion of jurisdiction and somebody coming within the jurisdiction that's going to be the critical issue here, and whether you feel that the line of cases, including Jaloud against the Netherlands and ZARSKY to a certain extent and other cases in the pipeline, could, when decided by the European Court, leach across not specifically into interpretations of the ICCPR, but into interpretations of customary international human rights law obligations. And whether that is something that could be, shall we say, prevented by certain pivotal states taking public positions on those issues.
Who would like to dare to comment?
Very, very good question. Yes. Yes, I was hoping we'd avoid customary international law.
So I guess one thing I would say to that, Bill, and thank you for your comment, is I don't see the United States, for example, shifting its view of the ICCPR jurisdictional coverage anytime soon. That's one of the reasons that what I was trying to do in my presentation in the paper I've written, from which it was drawn, is to focus on procedural aspects of surveillance that states might adopt, in part to kind of leave unaddressed this really sticky problem of the substantive application of the privacy norm in human rights. I don't have a view on whether that right to privacy has garnered a customary status at this point. And I might suggest that given ambiguity about its actual content, it might not have. But I guess I would say that one of my moves was to try to avoid that really hard question by suggesting there were other ways that states might come more quickly to agreement about certain rules that would signal a certain respect for foreigners' human rights in engaging this kind of surveillance without stripping them of total authority to do any of it.
So I alluded to it a little bit in my talk, that there is a very deep cultural element in privacy, law and concept, and therefore I see it a serious challenge in building in customary aspects of this right at this time. Now, some would say that after all countries are very similar on the basis notions in practice, but the theory is so different at this time, so it's very difficult for me just to wrap my head around coming up with such a customary concept at this time.
I'm not an expert in public international law, but from what I've read, there seems to be a fairly general agreement that the rights enunciated in the Universal Declaration of Human Rights are an embodiment of customary international law. And now, the equivalent of Article 17 of the International Covenant is found in Article 12 of the Universal Declaration. So one could argue that privacy is already in there in whatever form or whatever meaning it might have as part of customary international law. But I think trying to find the requisite degree of uniform practice and agreement is going to be difficult before you can definitely say, yes, a right to privacy in a particular context is part and parcel of customary international law. And that pertains to more generally to cyberspace behavior across the board. We don't have yet enough state practice that is of sufficient duration and definition, I think, to start saying, yes, customary international law plays a significant role in cyberspace governance.
Just to add one final comment to that in defense of the US on this. So I think the US is more transparent about the rules that regulate its surveillance, even its foreign surveillance, than almost every other country represented in this room. And that includes almost all NATO countries too. There is very little on the books related to foreign, purely extraterritorial surveillance, and I think that goes to Lee's point. If you were to try to sort of capture state practice and opinio juris on this, you might actually find more of it in US practice than in any other state's practice, for whatever that's worth.
Thank you. Another question? Yeah, the gentleman here.
Chris Inglis, teaching at the U.S. Naval Academy at present. Back to a jurisdictional question. Can you comment on the dissonance, possibly tension, set up by the assignment of competence for data protection, privacy to the EU, but the retention of competence for surveillance and intelligence by the member states? And as a case in point, whether the EU will stand in to France's recent legislative action where by a vote of, I think it was 438 to 86, they essentially introduced the possibility of sweeping laws that might seem to fly in the face of what the EU has articulated in Article 8.
I really can't. It's also a good question. I don't have enough inside knowledge to really answer it properly, so I'll pass.
No. Another question? Do we have a mic? Yeah, thanks.
Thanks. A very good panel has been observed. I'd like to just add a slight nuance to a particular line of argument that I've heard in a couple of panels, and this is the notion that the surveillance regime conducted by countries like the United States and the UK was associated with their core security interests, and that the reaction of some states was related to that was to say, well, that's an unjustified interference in our affairs. One of the reasons why states reacted in that way was that the United States was, and its allies like Australia and the United Kingdom, were overstepping their core security interests in what they were collecting. And they were clearly collecting it, as Snowden revealed, but as we already knew, for the purpose of direct interference in the domestic politics of the target state, not simply for the defensive purposes of understanding and protecting core interests. So that's a nuance I'd like to add. I have a question about the way in which those countries which were once in the vanguard of protection of human rights internationally now find themselves in the situation of acting defensively in the wake of the Snowden revelations and others to, in a sense, right away what you might call long-standing conventional rights or customary rights of their citizens. And for example, the Australian Attorney General has a proposition on its website right now which says that the process of warrants for searching was only ever meant to prohibit the most intrusive searches of government, not to provide an absolute right of privacy. And I cite that as an example of the way in which governments like the United States, Australia and the UK, once at the vanguard of the protection of human rights internationally, now find themselves in this unusual situation of having to sort of post facto justify things that they were doing and, in a sense, walk away from some of these what you might call customary rights of the individual.
Maybe Ashley, you have a comment?
You looked like you were going to say something.
I didn't hear a question mark there.
I could just add, as an Australian, I must say I've never thought of Australia as being ever in the vanguard of human rights protection. I think Australia is one of those legal cultures that incarnates Jeremy Bentham's attitude to human rights most clearly. That is, human rights is basically nonsense upon stilts. And it's one of the few Western countries that does not yet have a very comprehensive, constitutionally entrenched set of human rights. And that makes it much easier then for the Attorney General's Department to walk away from whatever protections we have had.
Yes. I guess I'd just say one thing, I think, to your first point, which was, I believe, was the U.S. truly pursuing a core national security interest rather than simply trying to obtain interesting information about a foreign partner? And I think that you've identified one of the reasons that the revelations or the leaks by Snowden prompted such concern is that there was this sense that this was no longer purely sort of counterterrorism. WMD is another state's military building up its weaponry, its weapons arsenal in a way we weren't anticipating, but that it did slide down a little bit. On the other hand, I would say that it is quite traditional for states to be interested in what the other states' foreign policies are. When Germany comes to the next negotiation with the US, what position is it going to take? States are traditionally very interested in that. So I don't think it was necessarily a deviation from the sort of historical practice, but the scope and quantity, the volume of surveillance, coupled with this sense that this wasn't for a totally core purpose, was part of what's created this concern and dissatisfaction about what's been revealed.
We have a question over there.
Thank you, Pascal. Kuba Mačák, University of Exeter. I'd like to go back to Ashley's paper. I have to say I found it really fascinating, and I liked the way that you structured your argument. So far we have focused maybe on the first step in the argument, so you have labeled it as the substantive step, and we talked about the jurisdictional aspects of it. But perhaps going further to what you have labeled the procedural aspect, then I would first of all put it to you that another way of thinking about it is the lex lata and then lex ferenda perspective on your argument. And so, to my mind, the proposal that you have made, the 6 norms, the 6 possible norms, the elephant in the room there, so the elephant in the room with the lex lata is the question of jurisdiction, and with respect to the latter, it might be the question of the possible take-up. So how realistic is this proposal? We have heard already during this panel's discussion about the limited number of state parties to the Budapest Convention. In one of the previous panels, we talked about the difficulties of the United Nations group of governmental experts to reach a consensus on even the basic fundamental norms regulating the situation in the cyberspace. So my question to you would be, what forum do you foresee for the take-up of these norms, and what form of these norms do you foresee, so that the proposal has as much realism in it as possible? Thank you.
So that's a great question. So on the broader question of how realistic is it, well, one of the reasons that I drew from existing domestic law and was looking for commonalities among states that had regulated extensively on domestic and transnational surveillance was an attempt to try to reach for norms that appeared realistic. Would it require a change in states' approach? It would, right? Because at this point, states are more attentive to and have greater regulation of the domestic and transnational than they do of the purely extraterritorial. But I would note that in a number of cases, the transnational surveillance implicates foreign actors, and yet, in the US anyway, US law provides a certain amount of protection for those foreign actors that happen to be communicating with people inside the United States. So I would argue that pushing it a little bit further to include purely extraterritorial activity, it's not starting from zero, right? We're starting from something more than zero. We have these norms, we know how they work, we know how they've played out, and so on. So I was trying to base the norms in existing laws of states and then pushing it a little bit further in application. In terms of what form I could imagine this taking, so again, I imagine that it would start among a pretty small group of states that would be basically having private discussions to establish, are there certain procedural norms, such as the kind that I've proposed here, that we could agree to. And so it could take the form of memoranda of understanding, sort of multilateral memoranda of understanding. It could even be a series of unilateral declarations by states that all pretty much said the same thing. You can tell, I'll just take a sort of random example. If you look at the states' reservations to Additional Protocol 1, you could tell that many, many states got together and formulated comparable reservations and then submitted them. So that kind of coordination, I'm not envisioning that this would be a treaty. I think that would be a bridge too far. And to the extent that these developed as customary rules, it would take a long time. And that may be kind of where we go.
So very quickly, I really liked the paper, and I said it might be, to myself, it might be interesting to run quickly the analysis that I drew out here regarding justifications and shortcomings to figure out if this is a feasible and helpful scheme. I'm not going to do that now. I'll just quickly say that on shortcomings, it's quite simple to see why it's a shortcoming, because once the other country knows how the surveillance is being carried out, they'll continue their communications in a way that's outside the realm of the spying country. Regarding justifications, the only quick point I'll make is that the argument that this will shame policymakers on a domestic level has a twist here, because internally the public probably can't care less. They're happy that they're spying on other countries. The twist is leading to the diplomatic incidents and the problems that come from other countries impacting trade and other relationships. And we should think about that aspect, is that a justification or maybe it's a shortcoming.
Right, I think the existence of a group of powerful corporations that are within the US putting a fair amount of pressure on the government to take certain steps to rein in its own activity sets the groundwork for the US to think about that. And if it thinks about that, it would probably want to do so in connection with some of its closer partners.
I think you had a question, Lee?
Yeah, actually I've got two fairly quick questions. One is to Tal and one is to Ashley. Tal, quickly on the downsides of transparency, one thing that struck me is that a possible downside is the syndrome where we're drowning in information. So if you've got untrammeled transparency, doesn't that then affect our ability to navigate properly?
Right, so you know what the difference in a conference is between a good question and a great question. A good question is one I have an answer for, and a great question is one I have a slide for. So I actually have a slide on that. I'm not going to bring it up. And in one of the slides I skipped through, thank you, is indeed transparency has benefits in terms of empowerment. However, we used to believe that transparency is a tool that allows us to all act on equal footing, but that's very far from true. Actually, once you have more information, the inequality comes into play by the fact that some people have better tools, ability, and equipment to analyze information, and therefore, when you generate greater transparency, you're creating greater inequality, but it might not be in my relation between me and government and me and collecting firm, but between me and analyzing firm that has the information, knows how to analyze, and something I do not know how to, and thus cannot benefit from it.
Okay, thanks. Then question to Ashley relating to your sixth suggested norm, where you'd have an oversight function by a neutral body. Are you intentionally backing away from the requirement of judicial review? I haven't read your paper, by the way, so I'm not sure if you
Yes. Well, I wouldn't necessarily say backing away from, because not every state that I looked at had judicial review. Certainly, I think only the US had ex ante judicial approval of certain forms of surveillance. A number of states do create either judicial or other mechanisms whereby somebody who claims that they have been offended by the surveillance or unlawfully surveilled may bring a claim that is then reviewed by a body. But I was trying to create a slightly more general norm that would embrace robust congressional or parliamentary oversight, inspectors general, these sort of other things that we see in the different legislation. So a strong form of the recommendation would be ex ante judicial review. But is that realistic at this point? I don't necessarily think so.
Thank you. Do we have another question? Oh, yeah, the lady in the back, please. And that would be, no, we might have time.
Jean Koshenda from Cisco. This may be a question for Lee. I'm not a lawyer, let me just say that, so speak on a normal person's level.
Or is it not?
I'm thinking about sort of the conversation that seems to be going back and forth between the United States and the EU to a great extent on the topic of surveillance and where the governments can go on this. And wondering if there's a pendulum swing, whether the EU is swinging in one direction while the United States is swinging in the other in some ways, and whether there's any chance that we're going to meet in the middle, or where do you see that, the pendulum going between, I guess, between privacy versus security?
Again, a good question. We're only getting good questions here. It's difficult to say at this precise point in time. I think back in 2013, just after Prism Day, then one could definitely have said that the pendulum had swung in a particular direction, that direction being that EU lawmakers were, fairly incensed. They were determined, particularly in the European Parliament, to get through the proposed General Data Protection Regulation. And they did so. In March last year, a huge majority voted for a version of that regulation that was not watered down. If anything, it was strengthened on certain points from the Commission proposal launched back in January 2012. And I think that show of force from the European Parliament was a reflection of a pendulum having swung sort of, up there. Where we are now is difficult to say, because the reform process hinges for the moment on the deliberations of the Council within the European Union. That is the representatives of the member state governments. It's expected that they are to come with their version of that proposed regulation later in June, but that will not be the end of the process. Then there'll be a trialogue between the Council, Commission, Parliament, and that trialogue will be again influenced by lobbying actions, covert, overt, and we have a new Parliament, so it's very difficult to do any crystal ball gazing here with any great certainty. But as I indicated in my speech, I think a lot of the puff has gone out of the rage, as it were, over the leaks from Snowden here in Europe. So I don't think the ongoing negotiations are going to be deeply affected by that. But there may be another Fukushima moment, as it were, or a privacy Chernobyl, that again affects that pendulum swing in surprising ways. All I can say is that we have interesting times ahead.
2 quick points. So I think Lee was interestingly, he was talking about regulation, the EU regulation proposal, which actually pertains to commercial entities, but here we see the impact by an event that regarded governments. So again, we see the relationship here, and in many instances, the relationship is manipulated by interest holders that take advantage of the Snowden affair and plant it in a context that's similar but has many differences. And my second point would be I don't know if it's even possible to talk about the EU as one country, one entity, and Lee specifically noted it. We have some countries that the current draft isn't privacy friendly enough and therefore might not join it. On the other hand, we have countries that find it too protective of privacy, too different from what their industries are telling them, and are objecting and even calling for very substantial changes that will bring the regulation under the threshold of the current 95 directive. So we see both of these dynamics, and therefore I don't know if it's correct to refer to the EU as one idea and one entity.
Thank you. Sorry, this is all the time we have for this fascinating session. I would like to warmly thank our presenters for their outstanding and tremendous presentations and exchanges. Thank you.